table to examine the federal government's posture toward firearms suppressors and to ask why the Department of Justice is still defending a regulatory scheme that Congress has already dismantled. Few products in America are as badly misunderstood as a suppressor. Hollywood has suggested and taught Americans that these devices are quote-unquote silencers, the tools of assassin and hitmen and special forces operators across the world that make a slight whisper when you pull the trigger. This is fiction. A suppressor is simply a hearing protection device. A rifle fired without sound protection registers, depending upon the rifle and the caliber, but around 165 decibels. That's louder than a jet engine and loud enough to cause immediate and permanent hearing loss. I speak from experience. I have a tremendous hearing loss, about 45% in my left ear, 40% in my right ear. Over the course of my service as a soldier and a police officer, from pulling the trigger sometimes without hearing protection. So a rifle fired without sound protection is dangerous simply because of its noise. A suppressor reduces that report by roughly 30 to 35 decibels. So it's still loud, still plainly audible, but less dangerous to the gun owner's hearing. The ATF understands this. The Bureau itself issues suppressors to some of its agents for their quote-unquote health and safety. What is necessary to protect a federal agent's hearing, it should be available to every American across the country. Study after study has found no meaningful connection between suppressor ownership and criminality. Actually, quite the opposite. In fact, one review of the decade from 95 to 2005 found that fewer than 0.1% of federal homicide cases involved a suppressor, and similar studies suggest that owners of suppressors are far less likely to commit a crime with that firearm than firearms available on the street. In 2017, ATF's own Associate Deputy Director concluded that suppressors should not be reviewed as a threat to public safety. So let's set the myths around suppressors aside and talk about the law. In passing the National Firearms Act of 1934, the NFA, Congress did not believe it could ban certain firearms outright, so it taxed them instead. The NFA has charged $200 per suppressor, or some worth over $4,800 by today's measure, if you go back in time, as a tax in order to implement a mandatory registration requirement for any firearms covered under the Act. In 1937, the Supreme Court upheld the constitutionality of the NFA's firearms registration regime, but only as a means of collecting the tax revenue attached to it. On July 4, 2025, President Trump signed the One Big Beautiful Bill Act into law, which set that zero tax dollars would be collected for suppressors. That tax was set at $0. However, the registration requirement survived. So did the felony penalties behind it. So while the tax foundation of the NFA was eliminated, the structure built upon it remains. So regular Americans are impacted like this. And I'm going to talk about one case that's, to me, particularly egregious. That's Mr. George Peterson. In 2022, federal agents hit his house. George Peterson was a licensed firearm dealer, but it was a small deal for him. He had a business, yes, but his business was out of his garage, connected to his house. And he followed the law. He was licensed, but he was no big gun dealer. And the ATF, in that oppressive era, of the ATF. You created a case against him and sufficient to get a warrant signed. They hit his house. They hit his house and terrified him and his family. And out of all the probable cause listed for the warrant that allowed them to hit his house, all of it evaporated. And they were left with one charge. George Peterson had one old manufactured suppressor in his safe that he had used for varmints and snakes around his property on a .22 rifle. And he'd have a snake in the yard. In order to not frighten his other animals and et cetera, he'd use that to kill that snake. It never rose to the level of significance for Mr. Peterson to register that thing. It wasn't high on his priority list. It was just a tool that he used. But at worst, you could say, well, you failed to register this suppressor. And indeed, that was a regulatory offense that he was charged with. But they prosecuted the hell out of this man. And yeah, that began under the Biden administration, but it continued under this one, under this DOJ. And Mr. Peterson was sentenced to 2 years in federal prison, where he sits right now. And I'm doing everything I can to help him and his family. His family had been crushed. This man's life ended because he had a suppressor in his safe in his bedroom, and he didn't register it with the federal government. And for that, he was sentenced to 2 years in prison. This is abhorrent, and every American tuning into this should pay attention, because that type of suppressor that George Peterson had, it sold untold numbers of these things as fuel filters across the country, right through the mail. You can order them for 40, 50, 60 bucks. And they were sold as fuel filters. What can I tell you? There's a loophole in the law. They sold hundreds of thousands of these things. So some of you Americans watching this, guess what you have in your house? Maybe sitting there. Of course you didn't register it with the ATF. It's sort of an absurd thing, you know? It's sort of a novelty deal you ordered without really thinking about the repercussions. Maybe you never even used it. But if you didn't register it with the ATF, and for some reason the federal government is going to cross your house and find that unregistered suppressor, you could be sentenced to 2 years in federal prison. Ultimately, the Department of Justice conceded the constitutional question, and thankfully now accepts that the Second Amendment protects suppressor ownership. However, DOJ defended Mr. Peterson's conviction on appeal anyway, arguing that a minor nonviolent failure to register a suppressor and pay a small $200 fee was worthy of the government investing its time and resources to tear a family apart and put a man in prison for 2 years. Presumably, that same litigating position binds every suppressor prosecution the DOJ has pending, even after the One Big Beautiful Bill Act eliminated the NFA's registration tax. Now, thankfully, it seems sanity is finally starting to prevail, but I take the position that all of these prosecutions should end and previous prosecutions should be reversed. Americans in prison for a simple registration of a suppressor charge should absolutely be set free. Last month, the federal district court in Texas held that the NFA's registration requirement is unconstitutional now that it is not tied to a revenue-generating tax. No tax, no registration requirement. No registration requirement, no prosecutions. Previous prosecutions that resulted in incarceration of an American citizen should be reversed. So my question for the DOJ is simple. Why is the federal government still spending taxpayer dollars in court defending this process that you have been told by a federal judge and by members of Congress and by the American people that you cannot lawfully enforce? DOJ's present posture towards suppressors belong to the anti-gun owner era of the Biden administration ATF enforcement. It does not belong in a pro-Second Amendment Justice Department serving a pro-Second Amendment president reflective of the American people that demand Second Amendment rights. We have assembled a distinguished panel today to help us understand this important Second Amendment issue. I look forward to today's discussion. At this point, I would recognize the ranking member, the leader of the Democrats, who do indeed populate this committee. However, they express their disinterest in Second Amendment issues by their absence today. So I'm pleased to welcome today's panelists. Mr. Knox Williams serves as the President and Executive Director of the American Suppressor Association, a nonprofit dedicated to suppressor advocacy and education. He's also a Senior Fellow for Second Amendment Policy at the America First Policy Institute. Mr. Peter Forcelli is a retired Deputy Assistant Director of the ATF and a former New York City Police Department homicide detective with 35 years of combined federal and municipal law enforcement service. Mr. Lawrence Keene is a Senior Vice President for Government and Public Affairs and General Counsel to the National Shooting Sports Foundation, or the NSSF. He is a member of NSSF's executive leadership team and serves as the organization's chief spokesman for all legal, legislative, and regulatory matters. We appreciate you all for being here today and look forward to your remarks. Let me remind the panelists that we've read your written statement and it will appear in full in the record, so please limit your oral statement to 5 minutes. As a reminder, press the button on the microphone when you're ready to speak. The light will turn green. After 4 minutes, it'll turn yellow. When it turns red, time to wrap it up. I now recognize Mr. Williams for his opening remarks.
Chairman Higgins, members of the subcommittee, thank you for inviting me to participate in today's roundtable. My name is Knox Williams, and I am the Executive Director of the American Suppressor Association, the nation's leading organization when it comes to firearm suppressor advocacy. I'm also the Senior Fellow for Second Amendment Policy with the America First Policy Institute. Suppressors are hearing protection devices, plain and simple. They are legal to own in 42 states, 41 of which allow hunters to use them, and they have been unjustifiably regulated since 1934 through the National Firearms Act unconstitutional tax and registration scheme. You can call them a muffler, a moderator, a suppressor, a silencer, or a can. It truly does not matter because all are terms to describe the exact same thing: a vital safety tool that helps protect the hearing of hunters and law-abiding gun owners who simply want to exercise their constitutional rights without permanently risking their hearing. Suppressor technology did not appear out of thin air. It is a direct derivative of the automobile muffler, which was invented by the same man who invented the suppressor, Mr. Hiram Percy Maxim, whose 157th birthday we happen to celebrate today. In 1895, Maxim invented one of the first gasoline-powered vehicles in American history. For the next 13 years, he helped lead the world's transition from horse and carriage to the automobile. Now, imagine a world in which cars did not have mufflers. Anyone who attended the Freedom 250 Grand Prix can attest that unmuffled cars are incredibly loud. According to the CDC, Indy cars, F1 cars, and NASCAR stock cars generate noise levels exceeding 130 decibels, often cited as a threshold for pain in human hearing. Repulsed by the extreme noises, Maxim invented a device to capture the engine's hot gases, allowing them to slowly cool. That device is the muffler. In 1908, he left his automotive career to establish the Maxim Silent Firearms Company, applying the principles of his car muffler technology to reduce another dangerously loud noise source, the noise generated by a gunshot. In 1909, he received a patent for his first commercial suppressor, which he called the Silent Firearm. Despite his marketing success and Hollywood-based misconceptions, no device can silence the noise of a gunshot. However, suppressors, or gun mufflers, absolutely do reduce the noise produced by a gunshot to significantly safer sound levels. But don't take my word for it. According to Dr. William Clark, director of Washington University School of Medicine's program in audiology, the most serious threat to hearing comes from recreational hunting or target shooting. That is a direct quote. Multiple studies have found that between 70 to 80% of hunters never wear earplugs or earmuffs, and nearly half of all target shooters don't consistently wear hearing protection. That's why the CDC, the National Institute for Occupational Safety and Health, the National Hearing Conservation Association, the Academy of Doctors of Audiology, Doctors for Responsible Gun Ownership, and the American Academy of Otolaryngology, Head and Neck Surgery all recommend the use of suppressors as a tool to mitigate preventable hearing damage. According to the CDC, and I quote, "The only potentially effective noise control method to reduce students or instructors' noise exposure from gunfire is through the use of noise suppressors that can be attached to the end of the gun barrel." According to a NIOSH study on noise exposure, if feasible and legally permissible, attach noise suppressors to firearms to reduce peak sound pressure levels. According to the National Hearing Conservation Association, the NHCA supports the use of firearm noise suppressors to reduce hazardous firearm noise exposures. And the Academy of Doctors of Audiology echoes this sentiment, stating, "Conventional hearing protection alone does not always offer adequate protection from noise exposure. Firearm noise suppressors can be an effective supplement to traditional hearing protection." Criminals are not interested in suppressors because they do not actually silence a gunshot. After all, how could a noise that scientists agree is still loud enough to warrant the use of hearing protection be quiet enough to not hear? That only makes sense in Hollywood. After the One Big Beautiful Bill Act eliminated the $200 tax on suppressors, the American Suppressor Association, the NRA, SAF, and FPC joined forces to file 3 lawsuits challenging the constitutionality of the NFA on the grounds that the 92-year-old law is a violation of both the Second Amendment and Congress's taxing power now that the tax has been eliminated. Those 3 cases are Brown v. ATF in the 8th Circuit, Roberts v. ATF in the 6th, and Jensen v. ATF, which was consolidated in Silencer Shop v. ATF in the 5th Circuit. Separate, but equally important, is the question of whether or not suppressors are protected arms under the Second Amendment. As noted before, conventional hearing protection alone does not always offer adequate protection from noise exposure to firearms. That means there are conditions in which it is impossible to prevent permanent, unnecessary hearing damage without using a suppressor. With that knowledge, how on earth could suppressors not be protected by the Second Amendment? To assert otherwise would be to claim that while the right to keep and bear arms may exist, the right to do so safely does not. On this question, my organization is involved with 2 lawsuits, one challenging the suppressor ban in Illinois and another in New Jersey. A third case is awaiting a ruling in California where there is an active split between the 9th and the 5th Circuits. Additionally, the DOJ amended their complaint in U.S. v. D.C. to include a challenge to the district's suppressor ban, the first time the government has ever acknowledged that suppressors are protected arms. Access to suppressors is a matter of public health and safety, period. The government should do everything in its power, including passing the Hearing Protection Act and urging the courts to lift restrictions on suppressors so that all law-abiding Americans, regardless of where they live, can exercise their God-given natural right to keep and bear arms without having to jeopardize their hearing. Thank you very much for your time.
The gentleman yields.
Yes, sir.
I appreciate him for his statements, and I recognize Mr. Forcelli for his opening statement.
Chairman Higgins, members of the subcommittee, thank you for the opportunity to appear before you today. I come before the subcommittee not as a representative of any political party or having any political point of view, but as a career law enforcement officer who spent 35 years on the front lines of this country's fight against armed, violent criminals. I began that career in 1987 as a police officer with the New York City Housing Authority and later served as a detective in the Bronx Homicide Squad, where I worked on over 600 homicide investigations. During that time, I also created a program called Operation Trigger Lock, which worked in conjunction with federal prosecutors and ATF, where we targeted people who were arrested in possession of firearms that were involved in violent crime. We referred about 250 defendants as part of that program. That program was credited with taking a homicide rate in the Bronx of roughly 600 murders per year to approximately 200 murders per year. That work taught me a simple lesson that I have carried for my entire career. When you take dangerous armed criminals off the streets and prosecute them federally, violent crime goes down. I carried that lesson 20 years at ATF, where I served as a special agent, a group supervisor, an assistant country attaché in Canada, and as the special agent in charge of the Miami Field Division, and then ultimately as a deputy assistant director and member of the government senior executive service. I led the investigation that resulted in the largest judicial seizure of firearms in U.S. history. I directed cross-border investigations into trafficking networks that armed Mexican cartels, and I led ATF's response to 3 of the worst mass shooting incidents in U.S. history. That at Fort Lauderdale International Airport, that at Marjorie Stoneman Douglas High School, and that at Pulse nightclub. I also came forward at great professional cost, in this very room, as a matter of fact, to testify before Congress in the Operation Fast and Furious debacle, in which flawed prosecutorial and management decisions allowed firearms to reach the hands of Mexican cartels, over 2,000 firearms, with fatal consequences, including the death of Border Patrol agent Brian Terry. I did that because I believe federal law enforcement only earns the public's trust when it holds itself to the same standard it applies to everyone else. That belief is why I am glad that this subcommittee's mission includes oversight of the very agencies that I served. I also have seen what happens when the system gets it wrong. Early in my career, my own investigative work helped exonerate men who had been wrongfully convicted for murders that they did not commit in Bronx County, 8 men, including one man who'd already served 20 years in prison. Aggressive law enforcement and getting it right are not intention, they are the same job when done properly. Finally, I stand before you as a survivor of the September 11th attacks on the World Trade Center and someone who later developed lung cancer as a result of my work on the pile. That day and the years since taught me that this country's safety depends on the willingness of ordinary people in law enforcement to do difficult and dangerous work, and that this Congress's willingness to give them the tools and the oversight and the support they need to do it well. I welcome your questions, and I thank you for the chance to have this discussion with you today.
Thank you, Mr. Forcelli, for your opening statement. We look forward to talking with you. I recognize Mr. Keene for his opening statement.
Chairman Higgins and members of the subcommittee, my name is Lawrence Keene. I'm the Senior Vice President for Government and Public Affairs for the National Shooting Sports Foundation, the Firearms Industry Trade Association. Let me begin by applauding ATF under the leadership of Attorney Todd Blanche and ATF Director Rob Sakata in lowering the wait times for 404 applications, the bulk of which are for suppressors. In January 1, the One Big Beautiful Bill reduced the tax on suppressors to 0. As a result, ATF experienced unprecedented surge in Form 4 applications. So far this year, ATF has approved more than 1 million Form 4s. ATF has been able to maintain historically low processing times, now averaging just 9 days, while receiving over 20,000 NFA applications per day. NSSF strongly supports the historic progress made with the One Big Beautiful Bill. However, the law did not remove suppressors and other NFA items from the NFA. While recently the U.S. District Court for the Northern District of Texas in the Silencer Shop Foundation case held that because the tax had been zeroed out, the NFA registration requirements for suppressors and other NFA firearms are unconstitutional. While DOJ deliberations continue about whether to appeal and seek a stay, NSSF has requested that ATF issue guidance to provide clarity to the regulated industry to ensure that companies remain in compliance with the law and act within the bounds of the permanent injunction. And Congress has an important role to play here. Congress should call on ATF to provide the necessary guidance. Guidance is needed on things like transferring or transporting these firearms across state lines, or whether ATF plans on continuing to enforce the enjoined NFA provisions against those who are not party to the injunction, and how ATF will handle the transfer of NFA items with no Form 4s from FFLs who are not party to the injunction, and how the injunction will impact ATF's policy on processing applications in the 15 states where state law is tied to NFA registration requirements. It's important to keep in mind that the permanent injunction may not be enduring. For example, if a future Congress were to reimpose the tax, thereby curing the constitutional defect, the permanent injunction would presumably dissolve. This would create a legal quagmire for law-abiding Americans who legally acquired suppressors under the injunction and without registration. They would suddenly be in possession of contraband, and they would be turned into felons overnight. The only way to make permanent and lasting change is for Congress to enact legislation that would remove suppressors and other NFA firearms from the NFA. NSSF supports legislation that would remove these firearms and modernize the outdated definition of suppressors. This would reduce ATF's paperwork and allow the agency to direct more resources towards combating violent crime rather than processing paperwork. Congress would also need to ensure that products do not fall under the jurisdiction of the Consumer Product Safety Commission. Congress long ago wisely excluded our industry's products from the CPSC jurisdiction because of valid concerns that remain that the CPSC would use its regulatory authority to impose backdoor gun control. In addition, Congress should preempt state laws that require NFA registration as a condition to lawfully possessing a suppressor under state law. It is important to recognize that suppressors help reduce the noise of gunfire to hearing safe levels, as my colleague Knox Williams has outlined. Suppressors are currently legal in 42 states and legal to hunt with in 41 states. And that's among the most popular reasons why suppressors are purchased, along with use in recreational shooting. There are unfounded concerns that suppressors will be used in crime, and as my co-panelist has indicated, that's not the reality, and as the chairman has indicated in your remarks, that's not the reality. They are not the tools of criminals, as Hollywood is portrayed, and some anti-gun legislators have misrepresented. Suppressor ownership has increased by 265% between 2020 and 2024. There are now over 6.65 million registered suppressors, and that number grows every day. Yet their use in crime is vanquishingly small. It's time to remove suppressors from the NFA. I look forward to your questions.
Thank you, Mr. Keene, for your opening statement. We're going to move into questions. I recognize myself for 5 minutes for questions. Mr. Williams, you have been deeply involved in several litigations you mentioned in your opening statement, correct? So is it an accurate assessment that you are broadly well advised in the realm of how Americans have been prosecuted for ownership or use of suppressors through several administrations, and including to right now?
Mr. Chairman, yes, sir. We are acutely aware of what has gone on for the past 15 years since our organization has existed.
So, because I just want to clarify that we're not just talking about one administration. We're not. Yeah, I'm actually not trying to place undue blame on the previous administration. Certainly not the current administration, whom I love and support. We're talking about correcting a generational mistake of criminalizing ownership and possession of a firearm safety device. The suppressor itself, Mr. Williams, is a suppressor, if it's not attached to a firearm, if there's no firearm involved, is it any more dangerous than a hammer?
No, sir. It is effectively a paperweight.
It's a paperweight. So we have criminalized the ownership and possession of a chunk of iron that is basically a club if it's not attached to a firearm. So we're talking about correcting 90 years of error. So you want to argue about court precedent and prior administrations and and the judicial proceedings and the history. Yes, it's all true, but it was all wrong all the time. And we're very close to correcting it permanently. But we do have, right now, at this time, the American citizens incarcerated or heavily penalized for no other charge. I'm not talking about an additional charge, like you were charged with criminal, arms trafficking and possession of drugs and an unregistered suppressor. Or you were charged with child trafficking and drug trafficking and possession of an unregistered suppressor. I'm not talking about that. I'm talking about Americans that have been charged strictly under the prior and existing laws that regulate suppressors and make it a federal crime to possess an unregistered suppressor. So what would you say, Mr. Keene? What would you say to the American's family who's currently incarcerated for only that charge? What are we going to do about it? Would you turn your mic on, please, sir?
We need to repeal suppressors from the Hearing Protection Act because, as you point out, it does not cause harm.
Okay, but not to interrupt the gentleman, but in a limited amount of time. You said in your opening statement that this requires congressional action. Let me say that that it would be nice to have congressional action, but absolutely not a requirement, because the executive has long established, if you want to talk about court precedent and criminal justice history, the executive has long established the authority to interpret existing laws and to enforce with discretion. If that's not true, please explain the lack of enforcement of marijuana as a controlled dangerous substance as currently scheduled. So the executive branch right now has the authority to reverse the prosecutions and incarcerations of Americans. What say you to those Americans?
I completely agree with you. As a former prosecutor, you always have discretion, and you should use it wisely. This administration should not be prosecuting people for possessing suppressors. My concern is future administrations may not hold that same view, which is why I think it's critical that Congress decide what the law is and not leave it to the discretion of a future administration that may not be friendly.
Thank you. Now we're on the exact same page where I was hoping to get. So it's incumbent upon Congress to act. We are first branch. We are a legislative branch. But according to the founders' intentions, much more difficult to pass federal law than it is to execute federal law and to interpret and execute federal law. So executive authority can move very quickly, whereas Congress moves rather slowly. And we're doing our best, and we're making progress. We have some dedicated Second Amendment constitutionalists on the Republican side of the aisle. There's four of them sitting right here that are members of Congress committed to this task. But I ask all of you to convey to our executive, including our Department of Justice, please, by God, reverse the injuries that have been brought upon American families and citizens over the mistake of the enforcement of laws that ban suppressors in our country for the last 90 years. My time has expired, and I recognize Mr. Gosar for 5 minutes for questioning.
Thank you, Mr. Chairman. A couple things. Around the world, there's like, take, for example, New Zealand. Why do they almost mandate that anybody who has a gun, it's difficult to get a gun there, but they almost mandate a suppressor? Can you tell me that, Mr. Keeney?
Because one, it makes it safer, it protects your hearing, it makes you more neighborly. No other country in the world regulates suppressors like the United States. They are ubiquitous in other parts of the world. It is considered rude in Europe not to use a suppressor, even when you're hunting by yourself in the wilderness, and certainly at public shooting ranges. You can buy suppressors at a hardware store in London. You can buy them in New Zealand. They come from China. They are like $25 Only the United States regulates suppressors in this absurd fashion, in my opinion. And the only reason I understand that they were included in the NFA was unfounded concerns from fish and game agencies across the country that suppressors would be used during the Depression to poach game, something that never occurred. And so the whole premise of them being in the NFA is a fallacy and wrong, and they should be removed from the through the Hearing Protection Act or other legislation. They don't belong in the NFA.
Could you repeat that? I'm a dentist, and I can't hear out of my right ear.
I think you should invest in a suppressor.
I'm just teasing you. So, but no. Now, it seems hypocritical to go along those same lines that law enforcement actually, or ATF, has their agents with suppressors, and yet the rest of us can't. It seems like it's a market being restricted. Freedom is being restricted.
I would completely agree. Freedom is being restricted. The courts are ruling that they are arms. The Third Circuit just yesterday, in a criminal case, said that suppressors are arms, just like the Fifth Circuit has said in the recent past. So they are unquestionably arms under the Second Amendment. And then the question becomes, how can they be regulated consistent with the test laid out by the Supreme Court? The courts have said, the Fifth Circuit, for example, and the Third Circuit just yesterday, that the NFA is a shall issue regime and doesn't infringe. If it's a shall issue and you're always going to issue the registration and allow a person to possess them, why are you pushing paper if you're always going to do it if it's a shall issue? You're still going to have a background check at retail through the Gun Control Act to ensure that the person acquiring them is a law-abiding citizen. But even there's a good argument they don't even belong in the Gun Control Act.
Yeah. Well, I would agree. Do you agree, Mr. How do you say your last name?
Forcelli, yes,
Forcelli,
I do agree. I don't believe they should be in the NFA. They are inconsequential to violent crime in the street based on my extensive experience in law enforcement. And yes, ATF agents are assigned suppressors with their weapons, and it's as a result of hearing damage that agents have suffered over the years, and to some degree traumatic brain injury from firing inside indoor ranges and whatnot. So I believe if ATF agents have that privilege, that should be extended to the general public as well.
I'm glad you brought up the aspect of brain injury, because we're now finding that there's impacts on the brain against the sides of the skull with a lot of repetitious gunfiring, right?
That's correct, sir.
Yeah, so the same thing that's happening in the NFL is happening with our guns folks.
Yes.
Wow. Mr. Williams, I just heard a comment basically saying that these are arms. How do you come to that conclusion that it's an arm? I don't get that.
That's a wonderful question, and that really stems back to 1934. As Mr. Keene alluded to, the National Firearms Act on itself had no actual debate when it came to suppressors. These were included as an afterthought. The first draft of that bill included suppressors for just handguns, and the original National Firearms Act included taxation and registration for all handguns. However, the National Rifle Association was able to get the handgun provision out, and when they pulled handguns suppressor, they left suppressors in as a blanket. I think it's worth noting, too, as it stands right now, this is a water bottle. If I were to tape this to the muzzle of a firearm, it would immediately become a suppressor. That is how ludicrous this law is.
Yeah, the only thing I could say to that would be that outside of a paperweight, my wife, she had a note to me, I just tape it to that suppressor and throw it and hit me in the back of the head. So that's, I yield back to balance my time.
The gentleman yields, recognize Mr. Sessions for a question.
Mr. Chairman, thank you very much, and thank you for the great hearing today. Gentlemen, thank you for your time and your expertise in this matter. Mr. King, good to see you again. I want to go down perhaps a pathway that I am interested in your opinion, and that is that when this case was first brought by the state of Texas against the United States, maybe 2 years ago, the very next day, the ATF raided a man in the congressional district that I represent. Came and were brutal with him. His wife was there. They threatened her. He was not there. at the time. They threatened him with putting him in jail. They took over $500,000 worth of guns, equipment, coins, a lot of things from him. And they told her, you will get your husband to open up this safe now, or we will put you in jail also, even though she was not part of the complaint. Since that period of time, it's been disappointing to see that the ATF, the vehicle which they took, has been driving around Houston, Texas on a regular basis. It's been seen driving around. It is ATF. Somebody is driving the vehicle. They have not returned his coins, his $500,000, his collection. And I'm sure that they feel quite justified because there were a number of these suppressors that he bought and did not pay the tax on at the time. So, okay, we get that. But now that the case has moved where it is, I'm interested in the Department of Justice understanding, as well the ATF, to issue the proper guidelines and things forward. I'm interested in the Department of Justice not further pursuing this matter in the Southern District of Texas. My dad was a federal judge for a number of years, served, as Mr. Keene knows, as director of the FBI. I've been around federal law enforcement a long time, seeing the Department of Justice, the way they operate. What's the right thing for a law-abiding citizen who got caught up in this to expect for him to be dealt with fairly now that he has waited these 2 years and the courts have done what they've done? Mr. Keene, you're a lawyer.
I'm not familiar with the particulars of that case, but I think every citizen should expect to be treated fairly and justly by its government. You know, the facts you outline are deeply troubling. I don't know whether they're driving the car because it's an asset forfeiture type situation. I have concerns about the abuse of the asset forfeiture statute. And
I do too.
Taking people's property, particularly later on and when the case is dropped.
Threatening his wife.
That's deeply troubling. I mean, I think that might be a matter that warrants investigation by the Inspector General of DOJ.
It does, and by the way, this gentleman here is a subcommittee chairman that involves law enforcement. I have government operations. These are government employees. I've tried to stay arm's length. I'm really not interested in pursuing the matter very much, except to say, Department of Justice, can he get his property back? I think that the matter, as it relates to the fines as a result of them taking his property and all that, is going to be unresolved, or will be resolved at some point today. It's unresolved. I just think that what we're learning, and Mr. Williams, you began alluding to this. The bottom line is that governments on political issues don't care about things. They want what they want politically, and they wanted to prove this, and I think that's exactly all three of your points. We need to make sure that we gather together what it's going to take and present the Congress to make law in this matter, because these are very unfortunate circumstances that take place with people who, really no fault of their own, believe we have the right to keep and bear arms, and that shall not be taken away from us. So I want to thank each of you for being here, Mr. Chairman. Thank you for the time. I would like to follow up with all three of you. Don't be surprised if I seek your data and information. Mr. Chairman, thank you.
The gentleman yields. Mr. Burleson is recognized for 5 minutes for questioning.
Thank you, Mr. Chairman. You know, I reflect on this. This is an amazing win for the Second Amendment. I'd love for it to go further. I'd love for us to continue to go further. But yeah, for decade after decade, it seemed like law-abiding gun owners were just getting kicked in the teeth when it came to having more regulations hoisted upon them, more difficulty being able to being able to purchase and carry the firearms. And we've seen that kind of freedom happen on the state level, but it has nothing has really happened on the federal level. And that's why I'm very proud to be a part of a body of lawmakers who held firm and demanded that we eliminate this unnecessary tax. And it's a huge win. And so my questions today is about the process for the current requirement to fill out the paperwork. So you still have to do a NICS check if you're Mr. Williams, you still have to do a NICS check, correct, if you're purchasing a suppressor?
Mr. Chairman, yes, sir, that is correct. You do have to fill out a 4473 of purchasing through a dealer, at least as we presently understand it.
And that's because it's listed by the 1968 Firearms Act?
Yes, sir, it's the Gun Control Act of 1968.
And that basically lists a suppressor as a firearm.
Mr. Chairman, yes, sir, that is correct.
Do you think that suppressors should be listed as a firearm?
Mr. Chairman, no, sir, I do not. It is ridiculous that these devices are treated the way that they have been since 1934. To undo a 92-plus year injustice is a tremendous opportunity. I feel like we are in the middle of the playoffs. We're in the middle of the World Series. We won Game 1. Now we've got to finish the drill and see if we can knock this out.
And that's just one area that we could be making some improvements on. What other areas do you see as low-hanging fruit that we should be addressing in Congress?
I think as it pertains to firearms, sir, the restrictions on suppressors are equally ridiculous when it comes to short-barreled firearms, whether it's short-barrel rifles or short-barreled shotguns, and I believe that cleaning those codes up is also an imperative.
Yeah, because we eliminated the taxes, but it's still, the code is still there that defines the difference between the two.
Yes, sir, that is correct.
And what I find is that when you talk to constituents, oftentimes it's the confusion that we've created in these statutes or these laws that cause them to have apprehension about entering into this, right? So if you don't know what the difference between short barrel and a regular rifle or a pistol, then and not everybody wants to dig out and read federal code in order to understand all of this stuff. And the question I have is, what's the difference, right? I mean, I understand the length is the difference, but at the end of the day, a firearm is a firearm. It performs the same function, whether it's short or it's a long barrel. And so a lot of this, in my opinion, is just designed to make it purposefully confusing and to trip up people and make criminals out of people that are just trying to either protect themselves or express their Second Amendment rights.
That's right, sir. You shouldn't have to have a law degree to be able to navigate the complexities of the federal gun code. And when you look at the way that the National Firearms Act is structured, originally they had handguns. It makes sense that you would have restrictions on barrel lengths and overall lengths in a scheme where you're restricting concealable firearms. However, as soon as they removed handguns from the National Firearms Act, it no longer made sense to maintain those restrictions on short-barrel rifles and short-barrel shotguns. You can have a small gun, you can have a long gun, but for some reason, this medium-sized gun is the problem.
Yeah.
It makes absolutely no logical sense.
It never does. And oftentimes, whenever I'm talking to people that are anti-firearm, that they don't understand the reason either. Let me ask about the fact that we still have this database in place. What would we need to do do you think that we should keep the records of, I think it's 6.6 million registered suppressors on file?
Absolutely not, sir. I would actually love to host a bonfire where we burn them all.
Sounds good. Thank you, Mr. Chairman. I yield back.
The gentleman yields. Mr. Crane is recognized for 5 minutes for question.
Thank you, Mr. Chairman, for holding this hearing on suppressors. Mr. Williams, would you agree that one of the main reasons that some elected officials and even citizens are hesitant to remove restrictions regarding suppressors is because they're pretty ignorant about what they're actually capable due to movies, they've watched and media that they've consumed?
Mr. Chair, Representative Crane, absolutely.
Yeah. I own several myself, and I mean, you watch these Hollywood movies and it makes it seem like they're whisper quiet, and that's not the case at all. I have several suppressors on rifles, and you still need hearing protection, you know, to use them. Mr. Furselli, did I pronounce that correctly, sir?
Yes, sir, you did.
You said you were a law enforcement officer?
35 years. I'm retired for approximately 5 now, but I spent 35 years in law enforcement. Yes,
Thank
sir.
you for your service, sir.
Thank you.
Where did you serve, sir?
And mostly in the Bronx as both a police officer, detective, and special agent with ATF. Then I served as a first-line supervisor in Phoenix. I served in a liaison capacity in Canada. Those Canadian cops can drink, I can tell you that much. Served as a second-line manager in Miami and as the agent in charge of the Miami Field Division, and then as an executive in headquarters, first as the head of operations for the Eastern United States for ATF, but ultimately as the head of training for ATF.
Whoa, I was about to run out of time listening to your resume there.
Sorry, sir.
No, that's great. It actually helps to, your resume actually helps for the question I'm about to ask. How many crimes did you investigate, sir, where suppressors were used?
2. Both of them were search warrants. Both of them were instances where people were involved in narcotics trafficking. Those firearms were not used in any violent crime other than being present at the scene of the warrant. And in the roughly 600 murders that I investigated as a detective with the NYPD, none involved suppressors. So in 35 years, I encountered 2 suppressors. Both were during search warrants, not incident to any violent criminal acts, just narcotics trafficking.
Mr. Keene, were you a prosecutor? Is that what you said?
Yes, I was.
Did you have a similar experience?
I never encountered a case involving a suppressed firearm.
So why do you think that is? We talked about how you can have a small gun, a pistol, you can have a long gun, but it's these medium-sized, guns, short-barreled rifles, suppressors that people freak out about. Why do you think that is, Mr. Keene?
I think they've been indoctrinated by Hollywood to believe something that is not the case. And criminals want concealable firearms. Having a suppressor on a handgun, as you know, makes it much more difficult to conceal. So you just do not see them being used in crime in any measurable number. And as I mentioned in my testimony, the massive increase in the number of suppressors in civilian hands is now 6.65 million and growing, and a steep increase, a hockey stick increase, if you will, in the last several years. You're not seeing an increase in the use of suppressors in crimes. It's just a total disconnect that law-abiding citizens having this hearing protection device somehow will translate to more violent crime. Quite the opposite.
And we've talked about your 2 individual experiences, but can we broaden the scope for a bit in looking at FBI statistics? Can you guys present us with any of the statistics as far as nationwide, how many criminals are actually using suppressors in crimes?
They're almost a non-entity, sir. They're not. And neither are short-barreled rifles, to be candid. Again, a short-barrel rifle is no different than a AR-15. Short-barrel rifle is no less a firearm than a AR-15 pistol, which you can buy that's not in the NFA. But to the points made earlier, when you put a suppressor on a pistol, that 9-inch pistol, 6-inch pistol becomes approximately a foot to maybe 17-inch pistol, depending on which suppressor you have and the length of the pistol.
Right.
So it makes a firearm less concealable, which criminals don't want. And candidly, you fire a couple rounds through a suppressed pistol and you try to put that firearm back in your pants, as criminals tend to carry them, you're in for a rude awakening because your skin's coming off.
Right.
So again, I think they're inconsequential to violent crime.
So we've already covered the fact that these aren't really being used in crimes. Mr. Williams, you talked about some of the health benefits of using suppressors in your opening statement. Can you briefly go back through that?
Sure, yes, sir. Look, the facts are there, right? The National Hearing Conservation Association, the Academy of Doctors of Audiology, the CDC, National Institute for Occupational Safety and Health, Doctors for Responsible Gun Ownership, the American Academy of Otolaryngology, Head and Neck Surgery, all independent medical organizations or branches of this government all recognize that suppressors are integral to hearing conservation efforts when it comes to firearms.
Thank you. We've had some pretty big wins over the last couple of years on this topic. My final question to you guys is, what would you like to see the next moves out of Washington, D.C. regarding suppressors? Mr. Furselli.
I think legislation has to change. And I say this because I retired from ATF when Merrick Garland gave a speech at ATF headquarters that was very adamantly anti-gun and very soft on criminals. And then after my retirement, I maintained contact with people and saw what happened when Steve Dettelbach became the ATF director and targeted the industry, and again, soft on criminals. ATF made its bread and butter by going after armed, violent criminals. That's where they should focus their limited resources and all of their efforts, not going after a boogeyman that's not actually that scary.
Thank you, Mr. Chairman. I yield back.
The gentleman yields. Mr. Perry recognized for 5 minutes for question.
Thank you, Mr. Chairman. Thank you to our witnesses. Sorry for my tardiness, and I'm going to ask you some questions. If you've already covered this, I apologize, but I need to hear it for myself and my bosses back home. So I have some concern. Look, I think this is great for freedom. It's great for America. It's great for self-defense. It's great for health. It's great for a lot of different reasons. I'm concerned about people not understanding on kind of all sides of the equation. Somebody that wants to own a suppressor, somebody that wants to sell a suppressor or short-barrel rifle, and then somebody on the law enforcement side, either by design or by mistake, persecuting people unduly for that. So if you could kind of outline, I sell stuff that's related to tactical equipment for shooting, for law enforcement or sporting or whatever, and I now want to sell suppressors. What are my limits? And if I want to buy a suppressor, what are my limits? Can anybody, is that easy to answer or not easy to answer?
Mr. Chairman, yes, sir. So it's a bit of a complicated question, and I think that this really gets to the core of the necessity for guidance coming from the DOJ and the ATF on this issue, especially in light of the recent court decision coming out of the Fifth Circuit. Traditionally, in order to manufacture or sell any item covered by the National Firearms Act, you have to first obtain a federal firearms license, and then you have to obtain an SOT, or Special Occupational Tax. That's the way that they have built this taxation and registration regime. In order to purchase one of these items as a consumer or non-licensed individual, you have to go to one of these licensed manufacturers or dealers, submit what's called an ATF Form 4, which is empirically similar in nature to a Form 4473, which is the form that you fill out when you buy a rifle, pistol, or a shotgun, a non-NFA firearm. Historically, until January 1st of this year, following the One Big Beautiful Bill Act, you have to pay a $200 tax anytime you purchase an NFA item. You still have to submit fingerprints, passport-style photos. You submit that in an application to the ATF, and the ATF then takes your information, transmits your information to the FBI. The FBI runs a federal background check. The same federal background check that they run on rifles, pistols, and shotguns. It's not some super secret, really intensive background check. It is literally identical. When your background check comes back, as it stands under this administration, the ATF will approve your application, assuming that there are no clerical errors, send that back to your dealer, and then and only then are you as the customer allowed to pick up that NFA item. I point out that in other administrations, this process has averaged anywhere from 6 to 18 months. So this idea that this is a shall issue regime is empirically false. It is not. With the Trump administration right now, it is running incredibly efficiently, and the ATF under Rob Sakata's leadership has been doing a fantastic job. The moment that there's an anti-gun administration, that could come crumbling down.
So the process you just described, filling out the forms and waiting, even though the timeline is much condensed under the current administration, that is the process under the court ruling, right?
So this is where it gets about as clear as mud. So under the court ruling, and please feel free to chime in on this, anyone who is a member of any of the covered parties, so whether it's the Jensen VATF, so that includes groups like the Texas State Rifle Association, the Citizens Committee for the Right to Keep and Bear Arms, or anyone on the Silencer Shot Foundation case, that includes groups like FRAC and GOA, any of their members, past, present, future, theoretically are covered as long as they live in one of the states where suppressors are legal. So there are 8 states where they're currently prohibited. You cannot, even with this ruling, you cannot go to a dealer in California and purchase a suppressor. In the 42 states where suppressors are legal, theoretically, you should be able to, under federal law, with this injunction, go in and purchase an NFA item, or one of these items like a suppressor, on a 4473, like you would purchase a rifle, pistol, or shotgun.
Without a Class 3 stamp.
That is correct. However, there are significant questions, and this is where we absolutely need clarification from the federal government to understand the intricacies.
So when you say the federal government, you got to be clear here, because I'm going to want people to watch this so that they hear your answer. When you say the federal government, we're talking about ATF or the DOJ, not necessarily, and it'd be nice if Congress provide the clarification, but we don't have the rest of our life to wait, right? So, right, for purpose of expedience and the ruling, we're talking about the regulatory agencies, which are the Department of Justice and the ATF, correct?
Yes, sir.
And what about states like the one that I live in, which is Pennsylvania, which have been somewhat restrictive? What do their attorneys general need to do to make sure that the law-abiding citizen isn't afoul of the law, and that law enforcement understands its limitations and jurisdictions as well? If you can indulge me, Mr. Chairman.
Mr. Chairman, thank you, sir. Yes, sir. I'm very glad that you asked that question. So there are 15 states whose state statutes in some capacity reference either registration or licensing under the National Firearms Act. That is an open-ended question. That is something that our organizations have been working to address proactively for the past about 18 months. We passed laws in South Dakota and Kansas this year. We've worked in about a half dozen other states and are working to fix that. The attorney generals, it depends state to state as to what sort of discretion that they have over their prosecutors within that state, and also how each state statute is written.
So is each attorney general in those states that have that requirement issuing a fact sheet, something that provides guidance to both citizens and law enforcement? And will the DOJ encourage them to do that, require them to do that? Or are they not required either way? Can they do whatever they, what's their latitude there?
I'm not aware of any requirements that they take action. However, what I can say is that we have been in direct communication with attorney generals from almost all of these states, and we'll have more information that I'd be happy to share with you.
That's going to be important, right? Citizens need to know that they're not afoul of the law, and law enforcement needs to know this is okay, this is not okay. And if you're the top law enforcement official in the state as the attorney general, even if you disagree or whatever, we need to know where you stand, right, as citizens and as law enforcement. Mr. Chairman, I appreciate the opportunity to yield back.
Gentleman yields. We're going to move into additional questions if my colleagues has any. I believe Mr. Gosar has an additional question.
Yeah, I think there's something else we have to do, and that is in ledge counsel. I think there's a bias in this place in regards to the way laws are written. I really do. And so we need to make, words matter. Words make a big difference. So I think it has to be very simple, very, very clear, and it got to apply all the way across the board. So the fewer the words, the better. And if you've ever been to ledge counsel here in this place, boy, they're windy. Boy, you see all the words piling up, because that's how they restrict us, is by the words. Would you agree, Mr. Williams?
Yes, sir. I think that's a fair characterization.
How about you, Mr. Keene?
Struggling with ledge counsel and drafting bills is always interesting.
Well, I think that's a great place to start, you know, and I think it would be nice that we involve outside counsel when we get a product back, saying, this is my intent, how does this work? Because if the lawmaker can get it right at the front, it saves a whole bunch of time at the back end. And once again, I'm going to hit this again. The other side demands that we have quiet technology with planes in the Grand Canyon. They demand all these different things based upon the science. The science is very clear here. And so we got to demand that from them. Same way. That's my question. Thank you very much.
Gentleman yields back. I have an interest in each of your opinions, gentlemen, on like clarifying the next step. We talked about, we are requesting that the Trump administration, through executive authority, present definitive rulings and articulate clearly the position of the executive branch and the ATF, DOJ, FBI, federal law enforcement, regulatory enforcement, as related to recent federal court rulings, and just to clarify for the nation. So we're requesting that of the executive branch. We are all leaning into into this body, the House of Representatives, and our colleagues in the Senate to support simple legislation that would address the listings on the NFA and to basically greatly simplify the existing complexities and to wipe away the complexities of the last decades as it relates to suppressors and also other NFA-listed items, but particularly this hearing is about suppressors. What else could we do? We have other court cases pending. We have some great confusions amongst the sovereign states, but we also recognize the rights of the sovereign states to have their own laws, but not if those laws are in violation of protected constitutional rights, individual rights, liberties, and freedoms. So there's a bit of a balancing act here, but I think it's uplifting to know that we're at that final point of balancing just how far do we go with this, and in order to restore constitutional rights that have been infringed and individual rights, liberties, and freedoms that have been infringed, while at the same time recognizing the rights of sovereign states. It's great news that we're at that point. It's very important, especially in this time potentially of transition of majority control in the House of Representatives or the Senate. That happens in America. And then we don't know what's going to happen in 2028 with the executive branch, but you could have a change of party there. So what would you gentlemen each, if you could do one thing, and we'll close out this gathering with your final recommendation. I ask you to keep it to a minute or less, but Mr. Williams?
Mr. Chairman, thank you so much, and thank you for the opportunity to discuss this. One thing, distilling it down to one thing, is removing these items from the National Firearms Act in order to restore the freedoms inherent to the Constitution, the natural rights that have been enumerated by our founders in the Constitution. I think to put a finer point on that, when we look at full removal of these items, I think that it is imperative, if Congress is going to take action, to include a provision like that included in the Hearing Protection Act, which includes preemption of these state laws. Any of these states that reference the National Firearms Act or its registration requirements are hereby satisfied by the passage and enactment of that law.
I agree. I think the NFA should be amended, and that suppressors and short barrel rifles should be removed from it. And look, it goes beyond just regulation. ATF obviously is probably the most involved in enforcing violations of the Gun Control Act and the National Firearms Act, but we need to keep in mind that other federal agencies also have those authorities, and other federal agencies have had missteps enforcing those laws in the past. So to clarify those laws, to make them easier for people to understand, will help avoid those missteps. So, but I think it's going to come down to legislation, because I've seen how another administration can come in and decide that they're going to focus on things that don't necessarily affect public safety, but do affect people that are in legitimate industries selling things that they don't necessarily like.
Mr. Chairman, thank you again for the opportunity to appear before you today. Let me just echo my co-panelist. We are at a tipping point on this issue, fortunately, and the time to act now, for Congress to act now, and that includes passing the Hearing Protection Act, passing the Short Act, removing short barrel rifles and shotguns from the from the NFA as well, and preempting state laws that allow possession under state law, provided you have you're registered under the NFA. Remove them from the NFA, be clear that you're preempting this, make sure they do not fall into the jurisdiction of the Consumer Product Safety Commission, and that is the best thing that Congress can do in the near term. And I would say close with saying, encourage the Department of Justice and ATF to issue the necessary guidance on the Texas case so people know what the rules of the road are between now and when you pass the Hearing Protection Act.
Well stated. Mr. Williams, Mr. Forcelli, Mr. Keene, thank you for being here today and for your remarks and your great wisdoms. I would yield to the ranking member of the Democrats for his closing statement, but once again, you seem to be unconcerned about Second Amendment rights, individual liberties, and protections. So, that being stated, this gathering of the Federal Law Enforcement Subcommittee, the Oversight Committee, is adjourned.